A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 20th webinar of Series 6 on Basics of Law titled Public International Law. This is the 58th BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chature Galhena, secretary of BSL, and Mr. Pasan Silva, treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the executive committee of BSL for all the support and guidance. For today's webinar of Public International Law, we have with us an esteemed panelist, Dr. Udara Soisa. Dr. Soisa is an attorney at law of the Supreme Court of Sri Lanka. He is the program lead for the LLM and LLB degree programs of Sri Lanka at the Bristol Institute of Business Management at University of West of England in Bristol. Dr. Soisa holds a doctoral degree in business management from Bern University of Applied Science, LLM in International Commercial Law from UWE, Master in Public Administration from University of Colombo, LLB from University of London, and BA in International Relations from Oglethorpe University. He is currently reading for his PhD in Law from University of Colombo. I warmly welcome Dr. Udara Soisa, attorney at law, for today's session. To moderate today's session, we have with us Ms. Rajintha Samaravikrama. Ms. Samaravikrama is an attorney at law of the Supreme Court of Sri Lanka and the Deputy Corporate Secretary at Dialogue Axiata PLC. I also warmly welcome Ms. Rajintha Samaravikrama, attorney at law, for today's session. And without any further ado, I invite her to commence today's proceedings. Over to you, madam.
Thank you, Isri, for the introductions. Good evening, everyone. At the outset, I would like to thank Dr. Udara Soisa, attorney at law, for giving me the opportunity to moderate at today's session. To start and set the stage for today's session, sir, can you explain what is the difference between international law, public international law, and private international law?
Yes, you can. Am I audible? I think I am, right? Okay, super. So this is a good starting question when anybody would like to study public international law, is to differentiate between what is public international law and what is private international law. So public international law, we will start with public international law, then we will compare with private international law, which is also called as conflicts of law, and we will discuss why this is in fact called conflicts. Now, public international law governs three symbiotic relationships. First, public international law governs the relationship between states and states. So you have states and state relationships. For example, if Sri Lanka and India has a border dispute, this would not be governed by the law of Sri Lanka or law of India. This would be governed by public international law, as we will discuss. Not only that, public international law also governs a relationship, legal relationship between states and international organizations as well. What are international organizations? International organizations are any organizations, right, in which states are parties. For example, a great example would be United Nations organizations, etc. So when we make up our chart, public international law governs the relationship between states and states, and also international organizations, and any conflicts that occurs between international organizations themselves. So if a UNDP, WHO has issued, international law would come to play in terms of whatever the treaties that they have signed between them. Not only that, finally, after the World War II, that means after 1945, that we so-called the Casases Fourth Era, public international law also governs certain relations between, right, states and individuals. For example, if a government decides to commit genocide, suppose, let's say, Indian government decides to kill all the Jews or Muslims, whoever, right? This would be an international incident because individuals are given rights as well as responsibilities under modern international law. So it is pivotal, it is significant for us to understand that the modern public international law not only governs the relation between states. Remember, states are the primary actors of international law, clearly, right? But however, for the last hundreds of years, perhaps 200 years ago, there were only states under international law. However, as international law progressed over the years, international law not only encompasses states, but also international organizations. We had in 1920s, we had international organizations like League of Nations, and now we have countless amount of international organizations, starting from United Nations, etc. And also, international law governs relationship between states, international organization, as well as individuals. So certain crimes done against certain individuals, protected groups, this would be governed by international law. So in a summary, we can define international law. I am taking, you can take several definitions. You can take Kasaroska's definition, or Cassases, or even Martin Dixon's definition, where international law could be summarized into law that governs relationships between states, international organizations, and international organizations, and their relations with individuals. However, when it comes to private international law, this would be how private individuals govern their legal relationships among different domiciles or different jurisdictions. For example, suppose you marry somebody. Let's say that you are, Ms. Rajinta, you are a Sri Lankan citizen. You go to UK, you get married in UK. Then you and your husband move to, let's say, Canada. And then you want to get a separation or divorce in Canada. But now the issue is, right, you are born in one country, your marriage is in another country, and now you're filing for a divorce in another country. So what is the validity of this marriage, right? Would the divorce that you got for the marriage in UK but in Canada, how would this be valid one day if you decide to move to Sri Lanka back again, right? So any personal relations, whether it's marriage, divorce, adoption, succession, wills, any private matters, right? Or we say personal law matters, any personal law matters that goes over single jurisdiction, the conflicts of those laws are governed by private international law. So essentially, we can say public international law governs relation between states, international organizations, individuals, etc., where private international law deals with cross-border disputes between private individuals and or companies, mainly focusing on jurisdiction, applicable law, and the degree and the mechanisms of enforcement. So I hope that for your short question, I have given a sufficient longer answer. Ms. Rajinta, any more questions?
No, that is clear, sir. So can I ask you, what are the main sources of public international law?
This would be a good starting point for this discussion to as moving forward. So when it comes to domestic law, finding sources are rather easy, I would say. Why? Because in domestic, municipal, same, if it's domestic law, municipal law, national law, what you have to understand is that there is a hierarchy of sources. There is a higher set of laws, as you know, in Sri Lanka and any other country. The highest law of the land would be the constitution. There are some constitutions like in Sri Lanka, United States, India, you have written, or we say codified constitutions, and some countries like United Kingdom, where we have uncodified constitution. But nevertheless, there are constitutional systems in domestic, if not, some people say domestic, some people say national, right? So some people say municipal, depends on how you like to word it, in such legal systems. The problem, the dilemma that we face in public international law is the clear absence, right? It is the clear absence of a constitution. So there is no global constitutional system. So how can we, in such a vacuum, how are we able to understand the sources? This is a dilemma that any international court would face. In this context, the Statute of International Court of Justice, that is the constitutional document, not for the international law, but for the International Court of Justice, which we will discuss later. So the Statute of International Court of Justice, Article 38(1), ABCD, list out sources of public international law. So there are several sources of public international law. This could be taken as an authoritative listing of sources. Remember, this is not the constitution of international law, but this is rather guidance given by International Court of Justice statute, the document for any judges, right, who are in international courts. Whenever a dispute comes in front of them, how they can, what laws to apply in remedy or resolution of such dispute. So Article 38(1)(a), BCD, they list out, right? Hierarchy. I mean, there is some argue there's hierarchical, but some argue it's not. It's debatable. But treaties, for example, right? Treaties, the first source I would say, and in terms of a source in public international law, would be treaties. Again, some people use the terms like conventions, agreement, etc. But technical word that you can use as the primary source of international law in the modern international law would be treaties. Secondary, there is a second source, which is customs. In fact, this is called customary international law. This you can take as the second source of international law. And there are also certain other sources such as general principles recognized by civilized nations. And also in terms of supplementary law, you can use judicial decisions of international courts and work or publications of experts, like highly publicized authors, you can take, but as supplementary. But the two primary sources of public international law would namely be treaties and customary international law. So what would be a treaty? Treaty would be an agreement that is between two countries. However, recent developments have indicated that there could be treaties between international organizations as well, between states as well. Traditionally, treaties have occurred between states. For example, I can take an example like Indo-Lanka Treaty. Right, Indo-Lanka Treaty. There is a lot of treaties between US, Canada. You can take the North Atlantic Treaty Organization, that is the NATO, that is again from a treaty. So you can take numerous treaties. So the treaties could be bilateral or multilateral, but never unilateral. What does it mean? For a treaty, you have to have at least two countries. You cannot have a treaty with one country, obviously. So for a treaty, you have to have two or more countries. In terms of customary international law, these are certain customs that are being used for longer period of time. There are two elements you must prove in a customary international law, like state practice and opinio juris, which we can discuss later. Now, what would be a traditional custom? Now, for example, you can take diplomatic immunity. That was a traditional custom. But now it is codified under treaty. So often you will find certain customs after long-term use and after more or less universal acceptance could codified for its usage as a treaty. But customs are certain practices. Customs are certain practices with longer duration, etc. If it has these two elements, right? State practice, that means significant states are practicing that custom. And opinio juris means states practice the custom with the understanding it is legally binding, right? So the state practice is the fact that physical element, and opinio juris is like a mental element. Think of like in criminal law, actus reus and mens rea, right? So if you can take it in that context. So there is a physical element for a crime and there's a mental element. So similarly, the physical element of customary international law would be state practice. The mental element would be the opinio juris. So second source I would give to you would be customary international law. First source would be treaties. Second source would be customary international law. And finally, there are other sources such as principles, right? This is not any principle. These are general principles recognized by civilized nations. I know this sounds a little bit like racist to say like it's civilized nations because mostly these are European nations. So example, human rights, proportionality, legitimate expectations, a lot of, you can take a lot of administrative law concepts here as well. So, and finally, in terms of supplementary law, you can take judicial decisions and this published work, etc. A key comparison would be judicial decisions in national law would be a very important source together with statutes in terms of interpretation, etc. Under national law, as all you lawyers know that we refer to cases often, they're not. But when it comes to public international law, cases are important, but not as important as in national law. Cases are important when there's a vacuum, right? When there's a vacuum and where there's a clear space in law, cases are useful as supplementary source of public international law, not a primary source of public international law. So I suppose we can summarize this. So what are the sources of public international law? Treaties, customary international law, general principles of law recognized by civilized nations, and you have supplementary sources such as judicial decisions and publicist works. I hope the answer is clear.
Clear, sir. Now you said that public international law is basically applicable to three actors in the international arena. So what if one of them breaks any rules? Who actually makes sure that they are held responsible for the actions?
Okay, that is a rather unique question. And I think one of the pertinent questions that most scholars of international law would always deem to be a central question, to be honest. So you cannot think of public international law in the same eyes as domestic law. These are two distinct and separate systems. As you know, as all of you lawyers would know, enforcement in national law is important. For example, let's say you murder somebody, it's important that these laws, the penal code will be enforced against you for your so-called murder. However, when it comes to public international law is universally based on consent. So states consent. It is a you could understand it as a horizontal system of law as opposed to vertical system of law. Like national law would be a vertical system of law. For example, state makes the laws and individuals at the bottom follows the laws. But when it comes to public international laws, all the states are equal in its sovereignty. This is the concept of sovereign equality, where all the states are equally sovereign. So the dilemma or the problem here is whenever a state or international organization or individual opts to break the law, there is no universal or compulsory court system that you could use to hold them accountable. International Court of Justice, you may say, might be option, but again, International Court of Justice is there not to punish countries, but rather to resolve disputes. So, for example, if Sri Lanka and India agrees to settle the matter through International Court of Justice, then the International Court of Justice will have jurisdiction to hear this case. However, when it comes to a situation where there would be no consent. Now, for example, look at a good example is you can take the example of the US. Recently, the US government under President Donald Trump has decided they will unilaterally bomb any suspected drug smuggling boats near the coast of Venezuela in an attempt to attack the Maduro's government. Now, we see that, there is no clear provisions under international law for one country to go to another country's territorial waters to blast the boats in such territory. However, the US continues to kill people, bomb people, right? This is a clear violation of public international law that even today that is happening as we speak. Another example that I could take is the Russian action in Ukraine, for example. So there is no right for a state under Article 2.4 of the UN Charter to enforce the international relations through use of force. No country, in simple, no country can attack another country. That is the whole point. But yet you see that is happening. Donald Trump thought, okay, it's a wonderful idea to go and bomb Iran. They will just bomb Iran, right? So if Russia thinks it's a great idea to annex Crimea or Ossetia, etc., they will go ahead and they will do that. And often powerful countries, like you could see that how Indians have violated the Sri Lankan airspace during like 1980s, etc., where powerful countries violate public international law. There is no real mechanism. There is a mechanism, for example, through the UN Security Council. But then again, who's in the UN Security Council? You have Russia, China, US, UK, right? And France. So in fact, if you look at those four countries, more or less 2, 3, 4 countries are the ones who are violating international law. The problem here is there is a concept called veto. So for example, if the United Nations Security Council were to take action against Russia, of course, Russia will veto it. If the UN Security Council want to take actions against Israel, you can see massive international law violations are right now happening in Gaza, in West Bank. In fact, Israel is one of the countries with the highest amount of international law violations. But nothing could be done because if the Security Council wants to take action, they can't. Why? Because there's a veto. There's this, like, you can kill the action through a veto. Because of the veto, United Nations Security Council will be unable to take any action. So to simply answer the question, unfortunately, enforcement is not a real strong point of international law, where even you can see certain international arbitration. Now, there was a recent arbitration between China and Philippines over South China Sea, where the arbitrator says, okay, these areas are belonging to Philippines, but then the China doesn't recognize the arbitral award. So what is the point? The problem is power plays a significant role in international law, and there's no clear-cut mechanisms otherwise than United Nations Security Council to take action. So it is not very efficient or possible for international law to address any clear breaches of international law, provided the breach is done by a powerful state. Any questions?
So following up on that, so do you mean to say that the international community doesn't have any recourse or to respond to these serious conflicts that happen, which are vetoed by the powerful states?
There is no clear-cut mechanism. For example, there could be certain regional arrangements, etc. But then again, look what's going on in Israel, Palestine. Look what is going on in Gaza. None of the Middle Eastern countries are able to do anything. The only way that Israel would respond if maybe US put some economic pressure on Israel, etc. Right? So unfortunately, yes, there you cannot have meaningful. You could have regional arrangements, but it is very unlikely to have a meaningful international arrangements whenever powerful states violate international law. This is why there are a lot of books even written in terms of international law where the might is sometimes the right, which is unfortunate, right? For example, US have committed certain crimes in some even argue war crimes in Iraq, for example, like in Fallujah, etc. But International Criminal Court has not prosecuted any Americans for the crimes that United States did in any country. However, they are prosecuting certain crimes now done by Russia, and perhaps you can see the arrest warrants against President Putin and also against President Netanyahu, right? But then Prime Minister Netanyahu, right? So now what you can understand, unfortunately, is that even the International Criminal Court is helpless. So International Criminal Court has issued an arrest warrant against certain leaders, But if the other countries do not respect these arrest warrants, what can be done? There's no international police to go and capture these international criminals, unfortunately, if they are the powerful leaders of powerful states, unfortunately.
So, in my understanding, state sovereignty is a key aspect of public international law. So, how does state sovereignty coexist with international obligations?
Yes. So again, how do we understand sovereignty? Sovereignty can be understood with two ways, right? One is supremacy, other one is non-interference. So supremacy means Sri Lanka. Now, for example, if you look at Sri Lanka's sovereignty, Sri Lanka is supreme in Sri Lankan territory and Sri Lankan territory waters, and no other states has the right to interfere with the matters of Sri Lankan law. So this is a sovereignty in a nutshell. However, we as a sovereign state can volunteer based on our consent to undertake certain international organizations. So in fact, international obligations are any consensual undertakings that a sovereign state has done for another state or for the international community, right? So for example, though Sri Lanka is sovereign, Sri Lanka has voluntarily accepted certain obligations through treaties and certain behaviors through customary international law. So you can almost say that sovereignty coexists with responsibility. So states remain independent. Clearly, states remain independent, but their freedom ends where the binding commitment begins. So, for example, we have freedom up until to this note where our binding commitments begin. So, for example, if you are given a commitment, right, to do ABC, we can go up to this ABC, and our freedom to do whatever we want will end at that point. Right? Why? Because we have given voluntary undertakings. We have given voluntary undertakings to follow these commitments. So in simply, state sovereignty is not absolute. States have voluntarily accepted obligations to treaties and customary international law. Sovereignty coexists with responsibility. Right? States remain independent. Yes, states are independent. However, their freedom ends where the binding international commitment begins.
So there are practical challenges arising out of these, trying to balance these two obligations and the sovereignty aspect.
Yes,
that's
correct. I can give you an example with Sri Lanka's ICCPR commitments, which have been observed over the years. For example, Sri Lanka is a party to the ICCPR. What is ICCPR? International Covenant on Civil and Political Rights. So what is the purpose of ICCPR? The purpose of ICCPR is to protect civil and political rights. But if you look at the absurd piece of legislation that Sri Lankan government has passed in 2007, which is the ICCPR Act, and its almost applications by the Sri Lankan, the policing, for example, there are examples, absurd examples, where people's civil liberties have been curtailed by ICCPR Act, which in fact was a domestic undertaking to give political rights to people. For example, ICCPR Act 2007 was enacted to bring in force ICCPR. ICCPR is a document which is one of the holy trinity of international civil liberties, with UDHR, ICCPR, and ICESCR. So the purpose of ICCPR is to give rights to the population. But look how the Sri Lankan police have been using ICCPR. In fact, how the Sri Lankan prosecutions have been using ICCPR. ICCPR has been used not to give rights. ICCPR has been used not to give rights, but to curtail. You know the recent cases of a comedian have been arrested, several years ago, arrested for insulting religion. But the way the provisions have been misapplied by the Sri Lankan law enforcement, almost pervert. It's a deadly perversion of our international responsibility. So though we have committed to protect international civil liberties through ICCPR Act, but however, since we are so dishonest, the Sri Lankan state has been so dishonest in its commitment, ultimately, you see that ICCPR is not, in fact, used to protect civil liberties, but to violate, to put people in jail without even bail for so many months, inhumanly, by the system. So, unfortunately, we have to understand those states take up certain international obligations. If the state is not honest, and if the state does not have integrity in terms of its undertaking, ultimately these undertakings would be ludicrous and absurd and will have no binding effect, especially in the domestic legal system. So this is the point, right? Sri Lankan sovereign state, though we have signed certain international commitments, ultimately, when it comes to enforcement, if we are not honest in our enforcement, these undertakings will not be useful. Go on.
Yes. Sir, we need to remind the participants to post their questions on the chat
Okay.
under the Q&A, sir. So, yeah. If you have any questions, please post the questions to sir and he will answer as we go along. Then, sir, I would like to ask you, what is the difference between recognizing a state and recognizing a government? And why does this matter in diplomacy?
This is more of a international relations question than international law, but it's fine. I will explain to you as much in terms of an international legal standpoint. So according to Montevideo Convention, this Montevideo Convention is the #1 convention which sets up guidelines in terms of how a state is recognized. So as per Section 1 of the Montevideo Convention, right, you see there are certain parameters for a state to satisfy in order for state to be recognized as a state. First, you have to have a defined territory. Now, Sri Lanka, for example, has a defined territory. We know the boundaries. So if anybody tell us, okay, if this part is part of Sri Lanka or not, we know that because Sri Lanka has a defined territory. Secondly, we have to have a permanent population. So it can't be 10 million today, 50 million tomorrow, 100 million yesterday. No, it is a relatively stable. I mean, it could, of course, fluctuate in decimals, but not it can't be huge fluctuations. So you have to have a defined territory. You have to have a population that is stable. And of course, the next stability comes from a stable government. So you could now, for example, you could have a country like Somalia, for example. Somalia has a stable, defined territory, population, capacity for international relations, but the government is not stable. So when the government is not stable, it would be a state, but it's something that we call as a failed state. So for example, if in Sri Lanka, if any Aragali or something just lasts for more than several years, then we don't have a permanent or stable government. We would be a failed state. Final parameter a state has to satisfy under Public International Law Montevideo Convention is the ability to enter into diplomatic relations. This is in fact not an internal parameter. This is external parameter. Why do we say it's external parameter? Because as you said, right, the recognition here by other state is subjected to what other states deemed. For example, certain countries historically did not recognize Israel, but then later on they recognize Israel, for example. However, when it comes to now again, when we are looking at Palestine, for example, now you can see more and more states are recognizing Palestine. So ultimately, you can see the statehood is not an internal element per se. Statehood is not an internal element per se. It is in fact, right, it is a mixture of internal elements and external elements. So when it comes to recognition, yes, I mean, ultimately international relations and politics play a role. Since Israel is committing genocide in Palestine and West Bank, you could see more and more states, including UK, etc., other than US, a lot of Western countries, etc., recognizing Palestine as a state now. So statehood would be a combination of that, right? Combination of internal elements such as population, defined territory, permanent population, and stable government. And also the final element you said about recognition by other states. So this mixture, right? So the total mixture here would create a state. But then there are states, for example, like Israel, right? All the states need to have boundaries, but if you look at Israel, there is no boundaries. For example, the today's boundary is like this, and tomorrow Israel has expanded with settlement. So, like I told you, international law is a relative reality where not all the countries at all the time follow international law. You'll always have several exceptional cases where some states does not fit into that model of statehood. But generally, statehood is covered under Montevideo Convention, where the 4 elements, like I said, right, need to be satisfied.
Okay, sir. So, coming closer to home, Sri Lanka has been in the United Nations for almost 70 years. I think it got membership in 1955. So, in your opinion, has being a member of the UN actually helped the country, or is it more of a symbol?
Yes, according to my analysis, I think it is a wonderful reality, because if you look at a lot of progressive elements of Sri Lankan constitutional systems, etc., you can see that, right? A lot of these things, a lot of certain, if you look at the fundamental rights chapter, why don't you take a look at the fundamental rights chapter in Sri Lankan constitution? Most of these elements, most of these rights, most of these articles are almost all of it has been derived by international law. So by us staying with the United Nations system, by Sri Lanka sticking to the United Nations system, what we do is that, we have consented to live under a system under UN Charter where we respect human rights, we respect state sovereignty of other states, and in return, we also get recognized. Not only that, we get certain aid, we get certain facilities, we get certain recognition, assistance. So, for example, you can see the wonderful contributions done by WHO during COVID. So it's practically, theoretically, conceptually, Sri Lanka being a part of the 193 United Nations member states is a wonderful reality. It is not a symbolic reality under any means. We have benefited immensely through various technical cooperations, whether it's in terms of children's rights, whether in terms of migration. Now, for example, I used to work with international, I used to be a communications officer back in 2010, 2009, 2010 with IOM, which is International Organization of Migration. I saw the great work that IOM did over the time, rehabilitating former LTT soldiers to allowing voluntary migration facilitations of people who have been, smuggled, human smuggling. So much is done now. If you look at UNICEF, so much work has been done, both technically and in terms of substantially, to improve the rights of children, right? And often they help up in terms of our drafting of certain legislative mechanisms, instruments, as well as stakeholders. So in my opinion, Sri Lanka's presence of United Nations, whether politically, whether ideologically, whether practically, in all sense, is a constructive and a positive reality that should be applauded and that should be continued for years to come.
Thank you, sir. So can I ask you, how does Article 51 on self-defense apply to modern threats like cyber attacks and terrorism? Like cyber attacks are quite prevalent these days, and I would like to know that how
Yeah,
it.
Now we will discuss one by one, because we cannot jump into Article 51 without talking about Article 204 of the UN Charter. So Article 204 of the UN Charter, clearly defines that a state is not allowed to use force for its international relations interactions. However, you know the laws, how the laws work, right? Whenever there's a law, whenever there's a rule, there are exceptions. That's how the laws work. That's why lawyers exist. For every rule, there is always an exception, and a good lawyer will always find that exception. So there are two exceptions. There are two significant exceptions for Article 2 of the UN Charter, which prohibits use of force. First one would be, as you said, Article 51. Article 51 allows states to use self-defense, right? Article 51 allows states to use self-defense to manage, right? To manage any threats if they are real and imminent when force is necessary. However, this measure should be proportionate. Furthermore, also take under Chapter 7, United Nations Security Council, where the Security Council is authorized, if again Security Council is not vetoed, they can take certain steps to preserve peace. So Article 51 is essentially to preserve peace whenever, let's say, country A attacks country B, until the UN Security Council gets involved, country B, who's the victim, can use force against the aggressor. However, now this is interesting because this UN Charter, which is in 1940s, literally, how many years? 80, almost 2020, yeah, so 8 years, right? So literally 1945 to 2025, so nearly 8 years, does not really address any of the modern problems, as you said. So one of the key issues I have now, for example, this is part of my research as well, whether current international law is enough under the UN Charter to ensure threats against terrorism, because you have to understand terrorism is asymmetric warfare, where you don't know. For example, a terrorist group in Sri Lanka might attack India, right? Then how can India respond? Can India bomb entirety of Sri Lanka, or can they send special forces to Sri Lanka to find and kill the terrorists, like what US did in Abbottabad against Osama bin Laden in 2011? So the law isn't clear, right? So the law under Article 51 is actually unclear, though there are several UN Security Council and General Assembly resolutions against terrorism and also cyber crimes. Article 51 in terms of defense against cyber threats and terrorist threats, especially if it is coming from non-state actors, is really unclear. This is where certain new reforms need to be introduced, right? Certain new reforms need to be introduced, but it's very difficult because to get 193 countries and also, you know, the veto power members to agree for this is very difficult because they all have their own agendas. But yes, you're right. So Article 51 is not necessarily equipped to deal with asymmetric warfare that is coming from cyber attacks or global jihad groups, etc. Not equipped.
So would you be able to give any examples where Article 51 was invoked? Has it ever been invoked previously?
Yes, I mean, countries invoke Article 51 at all given times whenever they are given their attack, for example, right? I can give an example where both Article 51 and to some extent Chapter 7 of the Security Council was invoked when, for example, Saddam Hussein, when in 1991, I believe, when Saddam Hussein invaded Kuwait. Remember, this time China and Russia was not so powerful back in 1991, and after Cold War, USA was the sole power. So in this situation, we had a unipolar world where United States government, especially under the Senior Bush, and also to some extent under Clinton later on, President Bill Clinton, the US was the only superpower in the world. So in fact, we did not see a real veto in the Security Council when Saddam Hussein attacked Kuwait and they were proceeding to take over the Saudi oil fields, etc. We saw that NATO, etc., took under both Article 51, collective self-defense, etc., of Kuwait, and under the authorization, the UN Security Council authorization, took action and defeated Saddam Hussein. And you could see also under Korean War in 1950, but in 1950s, we know that Soviet Russia was boycotting the UN. Why is it difficult? Why is it difficult for countries to use Article 51 or Security Council authorization? Mainly because of the veto power. Or when it comes to Article 51, also you could see more and more powerful countries justifying their attacks based on Article 51. For example, when Bin Laden attacked World Trade Centers, the second attack, 9/11, in 2001, you could say that United States attacked Afghanistan, completely wiping out or pushing out Taliban and putting their own puppet government. They use Article 51 also because terrorists were living in Kabul, controlling the Taliban government. So since this attack came from Afghanistan, we will attack Afghanistan and capture it, because we have a right to defend ourselves against the global jihadis. So Article 51 is used, but often by powerful countries. UN Security Council authorization also used, but again, very politically sensitive and not often as you would expect. However, don't get it wrong. I mean, don't think Article 51 and Security Council authorizations are useless. It is useful. In my opinion, we are living in a very peaceful world compared to the 8 years ago. Remember, in World War II, near 60 million, not 6 million, 60 billion people died. That is like 3 times the population of Sri Lanka died in the World War II. In Russia alone, 28 million Russians. I remember once having this discussion with, I think, one of the Russian ambassadors for the BCIS, and like 28 million people died, more than Sri Lankan population, right? By the World War II. And so much genocide happened against like nearly 10 million Jews, homosexuals, mixed race people died in Germany under Hitler. So we are not living in a horrible international law times. We are living in a debatable time. However, in my opinion, the world is very peaceful comparative to how it was back 8 years ago. Right? 8 years ago, we didn't have social media and media to this level. So we did not see the atrocities. We did not see all the atrocities that Hitler did, etc. So in my opinion, United Nations, Article 51, Security Council authorizations, etc., they're all very useful. Might not be as much as useful as it should be, but it's still something that need not be discarded. And that's something that has achieved global peace to a significant extent. It has achieved global peace.
Thank you. I know we touched on the International Court of Justice. Besides that, are there any other international courts or tribunals?
Yes, that's quite a good question. So International Court of Justice is the UN. Now you know that UN has several international organizations. You have the UN Security Council, General Assembly, General Secretariat, Trusteeship, Social Economic Council, and the International Court of Justice. So International Court of Justice is a world court, but in reality, it is the legal organ of the United Nations. So International Court is not a compulsory court. However, if two states wants to resolve their disputes, the states could go to consensually International Court of Justice and resolve their dispute. However, remember the consent here, Ms. Rajinta plays the key here, because if they don't give consent, right, then it's not possible. There are other courts, but these are not necessarily to punish states. Because of the concept of sovereignty, there is no real way of punishing states. However, there are ways you can hold individuals accountable. As you see with International Criminal Court, we spoke about International Criminal Court, also located in Hague, just like International Court of Justice. So International Criminal Court is established by Statute of Rome 2000, is the primary institution which has been established to punish international criminals. So there are several international crimes, as you know, right? Genocide, crimes against humanity, war crimes, crimes of aggression. These crimes that we know as the breaches of just cogence, Just cogence means the highest set of international law. So International Criminal Court is one of the courts. And before International Criminal Courts, we had Nuremberg trials. Remember, we had Nuremberg trials to punish the German war criminals who has committed utmost horrendous, brutish crimes in Nazi Germany. And we also have the Tokyo trials to punish the Japanese war criminals who committed horrendous crimes in Indochina, etc. You know that one of the highest number of rapes have ever in a war situation was done by the Japanese army in Indochina. So a lot of these criminals have been punished by the Tokyo trials. And you know that ICTY, International Criminal Tribunal Yugoslavia, punishing the Serbian criminals, etc. And you know that International Criminal Tribunal Rwanda, you know the conflict between Hutus and Tutsis, where these criminals have been punished. So we have certain mechanisms, but remember, these are mostly not to punish states, but to punish individuals. But then again, also very important in international law, because as I told you, individuals under international law now has rights as well as responsibilities.
So can you explain the difference between human rights law and humanitarian law?
Okay.
And how it works together?
Okay, Mr. Ajinta, I will do that. So international human rights law is applicable to at all times. What would be a human rights, right? What would be human right? What would be a human right? A right that you enjoy by virtue of being born, right? A right that you enjoy being born as a human being. So, for example, if if you are violated, if you are tortured, whether during wartime or peacetime, at any given time, human rights law would be applicable. But humanitarian law is actually law of war, right? There is a Latin word, right? Jus in bello, right? Just JUSINBELL, jus in bello. So what is jus in bello? It means how can you fight a war? What kind of weapons you can use? You know that in Hague Convention indicates the weapons that you can use at time of war. Also, you know that Geneva Convention, there are 4 Geneva Conventions. Who can be attacked? Can civilians be attacked during times of war? Can prisoner of wars be killed? No, right? This is why we know that even Sri Lankan government has to face a lot of criticisms and a lot of controversy when there were reports about this white flag incident, because we are unable to touch anybody comes with white flags. I mean, I'm not saying anything happened, but that would be a legal basis to discuss about, because it doesn't matter whoever the terrorist, if they come with white flags, etc., we cannot attack. Why? Because according to international humanitarian law, under Geneva Convention, we cannot attack any prisoners of war under any circumstances. So international humanitarian law governs the conduct of war. You can understand it as the laws of war, where international human rights law applies at all times. International humanitarian law applies only during armed conflict, whether this armed conflict is external, like between, let's say, India-Pakistan war, or the internal, like in Sri Lankan conflict, right? Sri Lankan Elam conflict. International international humanitarian law governs the conduct of hostilities and, most importantly, protection of civilians, right? So, in summary, human rights law applies at all times. Suppose the police torture you tomorrow on the way to courts. Yes, you have a fundamental rights case, again, based on human rights laws. However, humanitarian law would not be applicable because it is a time of peace. But if something happens to you during time of war, that would be a international humanitarian law matter. So if any issues with, if there's anything comes up with Chemini, etc., mass graves, that would be not just a human rights issue, it would be a humanitarian law violation also.
How do countries actually implement international human rights laws into practice?
I think, can I rephrase your question, Ms. Rajinta? How can countries implement international law in government, in national law? Would that be an okay question to answer?
Yeah, yes, sir.
So that, yeah, I mean, your question was great. I try to put it in a way that I could discuss it a bit more broadly.
Yes.
So, yeah. So, Ms. Rajinta, what we see here is constitutionally, there are 2 types of countries called dualist countries and monoist countries. In dualist countries, look at my hands, right? In a dualist country, international law and national law in a dualist country exists in separate realms. So international law is operating separately from national law. International law is operating separately from national law. In a monoist country, international law and domestic law both exist together. So in a monoist country, right? In a monoist country, let's say like Netherlands, France, example, in a monoist country, whenever the head of state enters into an international agreement, that law would be automatically binding, right? Because international law and national law are both connected at the same realm. In a monoist country, international law would be directly enforceable. However, in a dualist country, it is different. Like most countries in the world are dualist. Sri Lanka, US, India, except for very few countries, most of the countries are dualist to protect their sovereignty. They don't want international law to implement directly in the domestic mechanisms. So what you need to understand at the end of the day is, in a dualist country, a head of state signing international agreement doesn't automatically make it binding on the national law. So there has to be some kind of a legislative enactment. So for example, for ICCPR Act, after Sri Lankan government signed the ICCPR treaty, then Sri Lankan government has to legislate domestically under ICCPR Act to give it a legal force in its domestic jurisdiction. So in a dualist country, how can a state implement international law? There are direct and indirect ways of legislating this, drafting this. However, in a dualist country, whatever obligations that Sri Lankan government or any dualist government undertook under international law has to be accurately legislated in the national legislation, just to ensure that the international treaty or international undertaking becomes a domestic undertaking, right? So for example, if Sri Lankan government, Sri Lankan president signs a treaty X tomorrow in Paris, this would not be automatically binding on the Sri Lankan state for the internally. It will be binding externally, diplomatically, and under international law, but you cannot go to the Sri Lankan court system and enforce this international law. So for that to work, then the Sri Lankan parliament has to enact this treaty directly or indirectly into the legislative framework. Through this enactment only, right? Through a domestic enactment under a domestic legislation, only we are able to enact any domestic to ensure any domestic enforcement of an international treaty.
Thank you, sir. I would like to ask you, I think a lot of young lawyers aspire to join the UN agencies and so on. What skills do lawyers actually need to join these agencies, sir?
Sure. Now, for
And
example,
how can they start building that the requisite skills?
Okay, I think this is like, yeah, quite a practical question than a legal question. So I'll give you my example. So I worked for a couple of years with 1.5 years with IOM as a legal and mostly a communication officer. And also I worked with European Union projects for several EU projects over the years. My advice is developing language skills would be essential, because often what I see with a lot of youngsters is, okay, they are able to communicate properly, but the language to that higher level is a bit insufficient. And also I would say volunteer. There are a lot of volunteer opportunities with the UN volunteers, etc., that, just go there, attend those volunteer events. That's how I started as well. Just you start with volunteering. And also the UN usually now, due to the funding issues, etc., they advertise consultancies. So these are not full-time jobs. These are like 2-3 months. So when I first started working with the UN, I don't have any involvement with any UN agency after 2009, 2011, because I was with IOM from 2009 end to 2011. So what I used to do is I started as a consultant. So if you can, and also, I mean, back in the day in 2007, 8, 9, 10, there were more opportunities, I think, in UN, but don't only limit yourself to UN. Think of, you can see often the embassies advertising for the positions, even if you get like a smaller position, like a coordinator position or an intern position, even if you have like some serious work experience, if you're a lawyer for 8 years, 7 years, don't let your ego to hold you back. Just go and work with these agencies, even at a very lower level, because the good thing about international organizations is that if you have the capacity and if you have the attitude, you can easily come up. So there are two levels of at the UN. You have the coordinator level and the national officer level. So often a lot of people start as a coordinator. So they have the P level and I think the national NC levels, etc. I don't remember exact classification there, but anyway. So my advice is volunteer. Try to go for whatever the events that you can take, even if it's volunteering, even if it's like very little amount of stipend, put your head a little bit at some level. And then ultimately, like I say, if you hang out around a barbershop, you'll always somehow at some point get a haircut, right? So volunteer as much as possible, volunteer, because it is very unlikely that you will have a direct access right now, because after 2009, 2010, funding for a lot of agencies have dried up in Sri Lanka. And other thing is also look at some opportunities abroad as well. So if you go to unjobs.org, you can find certain opportunities in some other countries as well. So maybe work in some other countries, in certain African countries, etc., that you can apply. I think maybe have a master's, a good master's recognized at international level, develop your English, and ensure if you want to do, if you want to go into international organizations, that your master's and your research is tailored to that end. So balance your education and also maximize your exposure, because it's all contact. So if you get to meet people, they recommend you. In my opinion, I think they're always looking for people, but whether you'll find a place in Sri Lanka or abroad, that is, the question. But remember, if you get an opportunity abroad for the UN, the advantage I have seen is there's a lot of compensation, because by law they have to pay you the relocation fees, etc. So I've seen quite a lot of people. In fact, I have several of my students as well who are seeking, who are doing quite good jobs, not necessarily at the UN, but at international level. So develop your language, get good exposure, get a good postgraduate experience.
Thank you, sir. Sir, how do you see public international law evolving to handle geopolitical disputes like Kosovo and Palestine? Are there new approaches or trends we should watch out for?
Yeah, that's interesting way of looking at it. So Kosovo, I think, is all more or less all story. However, when it comes to Palestine, I think you can see the concept of self-determination again getting some friction, some start. Why? Because you can see that with the Russian occupation in Ukraine, for example, people start talking about self-determination rights of Ukrainians, and especially in Palestine issue, right? And then also you can see in Kashmir, I think self-determination, also human rights. Some say this is not a very good era for international law, because you see with now, recently I saw an interview between Donald Trump and one reporter where, often we can see whenever there are Republican leaders in White House, the human rights and international law focus is very less as opposed to Democratic leaders. So not maybe a very good time for international law also, because you can see a lot of countries violating international law. I mean, I can list you so many countries. Look what China is doing in South China Sea, what Russia is doing in Ukraine, what USA is doing in almost everywhere, right? They just totally go against the trade laws, against the World Trade Organization, their own standards, putting tariffs. I saw this news on CNN that Donald Trump put a 50% or some huge traffic on Canada just because one of the Canadian the state governments put a mocking advertisement on Trump, right? So you can see it might be a bit of a dark era for international law, because you can see that realism under international relations are taking more of a center stage, where often international law is being given the stepmotherly treatment.
Okay, sir. We have got some questions. Can I read that to you, sir?
Yes, so we have around 20 minutes, so we will quickly go through the questions. Yeah.
So one question is, speaking specifically about Sri Lanka, recently there was some discussion on a few controversial bilateral agreements. Of course, even before such controversies on bilateral agreements have been there in Sri Lanka. Do these agreements become law of the country, or are these agreements respected as a matter of committee?
So yeah, so now when it comes to international law, we need to understand about dualism. Dualism. You have to understand about dualist system, right? You have to understand about the dualist system in Sri Lanka. So when Sri Lanka signs an international agreement, whether it's IMF undertaking or anything else, we are bound by it under international law. So what if we don't follow it? Well, we might not get any other funds from IMF ever again, right? So we might have a huge reputational damage. We might, be liable under certain, international arbitration, etc. But domestically, this is not like you can't be bound. So how can this be enforced domestically? How can this be enforced domestically? You can enforce this domestically simply, right? You can enforce it simply by legislating. So if the Sri Lankan government does legislate any of these international instruments that you discuss, in that context, these legislative documents, though the acts, whatever the ABCD acts sign and pass in the parliament, would be valid. But just because Sri Lankan government signed a treaty, that would not have a domestic or municipal enforcement validity, because Sri Lanka is a dual state. But practically, Sri Lanka would want to pass this, right? Otherwise, it makes no sense. Sri Lanka signs it internationally and they don't pass it domestically. Then there is a discrepancy and inconsistency between Sri Lanka's global undertakings and Sri Lanka's domestic legal undertaking. So essentially, if Sri Lanka signs a treaty, then to some extent they'll have to domestically legislate it. But then that there could be a certain opposition for certain acts, etc.
Thank you, sir. So there's another rather interesting question. When state sovereignty conflicts with universal human rights obligations, should international law prioritize sovereignty or human rights? And how should that balance be practically enforced?
Yeah, so the concept of sovereignty, there's a classic, there's a two ways we look at sovereignty. One is a classic definition of sovereignty. Other one is the modern definition of sovereignty. So if you look at this classic definition of sovereignty, the sovereignty was almost absolute. So if you look at Nazi Germany, for example, when Hitler was killing millions of Jews, did Churchill get involved? Churchill said, no, I will not get involved with this matter, though the Nazi Germany is committing this crime, because this is a domestic issue of Germany. We don't want to get involved. We don't want to violate German sovereignty. So this was the concept of sovereignty before 1945. After 1945, what we can see is the concept of sovereignty is becoming more and more relative, right? So the concept of sovereignty is becoming more and more relative. So what we see here now under international law is the fact that we are sovereign. Our sovereignty is almost relative. So Sri Lanka is only sovereign to the point that we protect fundamental rights and human rights. So for example, if Sri Lanka is killing all the Tamils or Sinhalese or Muslims, we are committing genocide, then there are other concepts like humanitarian intervention, R2P, responsibility to protect. Then the other state might through under certain application of certain customary international law, we try to interfere in the matter. So yes, there with the modern concept of sovereignty, which is a limited concept of sovereignty compared to the classic concept of sovereignty, which was absolute. Yes, sovereignty is almost dependent or relative upon our adoption or our compliance with fundamental rights. So if the Sri Lankan state continuously violate fundamental rights, it would negatively impact our sovereignty. So you cannot don't try to understand sovereignty and human rights as opposing elements. Try to understand sovereignty and fundamental rights as a concurrent reality where one is dependent on the other. So try to understand this like a confluence than any conflict in reality.
Thank you, sir. There's another question. As digital platforms operate without clear territorial boundaries, do traditional private international law tests such as lex loci delicti or minimum contracts still hold value? Or should we advocate for new doctrine entirely for digital harm?
I mean, our main focus today is public international law. I would not like to go deep to the private international law, but since you asked the question, I want to explain to a little extent. But then again, I'm not answering a public international law question, but I'm going totally out of the syllabus to talk about private international concepts of domicile, domain, etc. Yes, I think just similar as my answer for public international law, you could see that there are certain. The modern application of private international law would not be as strict as classic doctrines. So you could see a sense of a relative application, but I don't want to go too much in it because that has nothing to do with public international law. But this is a total question on private international law. Maybe we'll do another session on private international law later on, but going furthermore, we'll just confuse people on public international law. No worries.
Those are all the questions that we have got, sir, for today.
Okay, wonderful. I think we can wrap it up. So couple of additional things that I think we can keep an eye open in terms of public international law, right? We need to understand certain trends, like you said, right? Individuals are being given more and more recognition in public international law because it's very ironic, isn't it? Public international law is supposed to be between states and states, but in the modern public international law, individuals and other non-state entities are also given recognition, rights as well as responsibilities. When you are given rights, you'll always have to have responsibilities. So understand there are modern trends of public international law, such as individual recognition, proliferation of rights, right? And also with nuclear weapons, etc., new legal regimes coming up. You all have to understand that international law and international politics or international relations are like almost different sides of the same coin. In fact, for international relations to work, international law has to work. For international law has to work, international relations has to work. So you have to understand, to some extent, international law is the I would say enforcement mechanism of international relations, right? It is a legal system which is under the international relations system. So with that, I would like to end. And if there's no more questions, I would like to end the brief presentation. And thank you. I would like to thank for the opportunity, and it was wonderful doing this short seminar. And hopefully we can continue. Thank you.
Thank you, sir. As we wrap up, I would like to thank Dr. Udara Soiza for sharing his valuable insight and perspective on international law. So international law is complex and ever-changing. We hope today's session helped clarify how states, organizations, and individuals navigate these rules and responsibilities. Isuri, it's over to you.
Thank you, madam. This brings us to the end of the 20th webinar of the series on Basics of Law titled Public International Law. I thank our esteemed panelist, Dr. Udara Soisa, Attorney at Law, and our moderator, Ms. Rajinta Samarvikram, Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this webinar. I also extend my thanks to all the participants who have joined in for this session today. Thank you, and I hope you all have a very good night.